You'll come around, please. I'm going to ask you to raise your right hand and be placed under oath.
Would you state your name, please?
Nedra Patterson.
Would you spell it for the court reporter, please?
Nedra, N-E-D-R-A, Patterson, P-A-T-T-E-R-S-O-N.
And Ms. Patterson, you testified at the trial in this case.
Yes,
And you know Ms. Kelly?
yes.
And could you tell us how you know Ms. Kelly?
She's my neighbor.
And could you tell us generally about your relationship with Ms. Kelly?
We're friends. Just not neighbors, we're friends.
Briefly, could you tell the court about where Ms. Kelly lives and what that parcel looks like?
She lives in Sladen. She's next door. There's a house, 2-story, cars. She takes care of it.
I mean, is it a large parcel? Is it a yard or is it several acres of land?
It's acres of land.
So it does take some management.
Yes,
And you're aware of who lives with Ms. Kelly?
yes.
Do you think that the property would be managed or taken care of the same level if Ms. Kelly was not there to do it?
No, I don't believe so.
And do you know Mr. Levi Kelly?
Yes,
And he's a new adult, I guess would be
Yes.
the way to put it.
he's 18.
And do you feel like that he needs supervision from his mother?
Yes,
And do you know, is his father, does his father live there in the home?
no.
And have you ever relied on Ms. Kelly regarding her trustworthiness or dependability?
Yes, I have. My car broke down and I was unable to go.
This is the moment everything shifts. Up until now, it's been legal arguments and technicalities. But this right here is raw impact. A child describing permanent nerve damage and broken trust? That's not just evidence, that's emotional gravity. Question for you. Do you think victim impact statements should influence sentencing this heavily?
Mr. Belmont, you may call your next witness.
Application for certificate of diversion. I would note that it does reference prior undisposed cases out of state, references NCIC report, which is in the pre-sentence report. And I would submit, Your Honor, that, and I'll argue it, but I'd ask the court to at least consider that, and if the court determined to allow judicial diversion conditionally upon us providing certified copies of both of those cases from Texas were indeed dismissed. So, but that's all for our proof, Your Honor.
Any rebuttal proof? And I'll hear you in argument.
Judge, I'd like to first address the issue of judicial diversion. And in doing so, I'd like to refer to the case of State v. Finch, F-I-N-C-H. The citation on that is 465 Southwest 3rd, 584. It's a 2013 case. Judge, it was partially overruled. That overruling has to do with the criminal savings statute that was passed in around the time of 2019. So what I'm referring to on judicial diversion has not been overruled. Judge, in that case, it reviews a defendant's case where she was eligible for judicial diversion. It says that the decision to grant diversion lies solely with your discretion of the trial court. It is not disturbed on appeal unless there is an abuse of discretion. They will not revisit the issue so long as any substantial evidence exists to support the trial court's action. The grant, when you make this decision, you are looking at something to determine if it will serve the ends of justice for both the public and for the defendant. This opinion lays out 5 factors that the court must review in determining whether or not to grant judicial diversion. First, the defendant's amenability to correction. Second, the circumstances of the offense. Third, the defendant's criminal record. Fourth, defendant's social history. Fifth, the defendant's mental and physical health. And I'm sorry, there were 6 factors. And sixth, the deterrent effect of the sentencing decision to both the defendant and other similarly situated defendants. When ruling, the record must reflect that the court has considered and weighed all of these factors, and the court must explain why the defendant does not qualify under your analysis, and must explain why some factors outweigh others. This opinion also states that the denial of judicial diversion may be based solely on the nature and circumstances of the offense, so long as the other relevant factors have been considered, and that this factor outweighs all others that might favorably reflect on the defendant's eligibility. Judge, I would submit to the court that that is the case, both in my argument on diversion and on whether or not this sentence should be probated or a sentence to serve. You heard proof at trial of the substantial injuries to this child. And whatever the theory of conviction, the level of seriousness of these injuries does not change. Photographs were put in proof of the injuries at the time the victim went to the hospital. At the time of the trial, the victim actually went around and was able to show the jury the injuries still to his wrists that are visible to this day. And this child will live with the consequences of the defendant's actions for the rest of his life. And as such, the seriousness of this offense, the injuries to the victims is so substantial at his young age that we would ask that diversion be denied and that the defendant be given a sentence fully to serve.
Mr. Bell-Myers?
No, Your Honor, heard the case. It's a lengthy trial. The facts of the case, or what the jury believed the facts to be, and what they acquitted Ms. Kelly of, and what they found Ms. Kelly guilty of. She was accused of tying a child up. She was acquitted of tying a child up because that offense was the intentional tying up that caused serious bodily injury, was aggravated child abuse. It wasn't that the intent was to cause the injury, the intent was to tie the child up. She was acquitted of that. She was convicted of reckless endangerment, and I think what the court should consider is the last question that the jury asked almost immediately before returning a verdict is failing to act enough to convict of reckless endangerment? So in my mind, it settles that the jury believed that what Ms. Kelly did wrong was failed to act. Not that she tied the child up, not that she caused the injury, but she failed to act. Now, so that's the facts and circumstances I believe that the court should consider. Just because the state accused someone of something, if they're acquitted of it, then I don't think the court should consider that regarding their sentence. Also regarding that, I'd ask the court to consider that at that point in time, we were all under COVID restrictions where we were told, don't bring someone to the hospital, don't bring someone to the doctor unless they are in grave danger. That there was a risk that you would contract this disease that could possibly kill you if you came to the hospital. So that's something I think the court should also consider as a fact to the case. Amenability to correction, there's absolutely nothing in the record that Ms. Kelly would not be amenable to correction. You had the pre-sentence report, the probation officer that believes she is. You had her friend and neighbor that believes she's trustworthy and dependable, both of which go to ability to successfully complete probation. Criminal record, there's no convictions in the criminal history. Social history, to admit that she is divorced. There are a lot of people that are divorced in the world. You heard a little bit about the circumstances, at least about that marriage. So that's something for the court to consider. Health, it is reflected in the pre-sentence report that she is disabled due to a back issue. And then deterrence. Again, if you look at the facts of the case and what Ms. Kelly was convicted of, there's no need for deterrent effect. Mitigating factors that I'd ask the court to consider would be number 3, substantial grounds exist for tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. If Your Honor recalls, we asked for a necessity to defense. The court found that it wasn't applicable, but it's the same type of argument. She would have to weigh, do I take this child to the doctor, to the ER, or do I keep this child at home and try to treat him at home? And then also number 11, the defendant, although guilty of a crime, committed the offense under such unusual circumstances, unlikely that sustained intent to violate the law motivated the criminal conduct. And then, as well as that, Your Honor, she's not around the child. You've heard that she's severed ties with the child and the child's father, which is her son. So there's really no need to incarcerate her to prevent her from being around the child. You've also heard that she does have while he is an adult, an 18-year-old son at home that relies on her for care, Your Honor. And for those reasons, we would ask for a suspended sentence and also diversion. And she did serve, I believe, a little over 30 days in jail before being able to make bond in this case.
Anything further, General? All right, this case comes before the court, and I'm going to deal with, first of all, the issue about judicial diversion. The case that the state has cited, which is State versus Finch, which is in the Court of Criminal Appeals from 2013, does set forth the factors that the court is required to consider. But there's language that applies to this because I want to make sure that the record is complete. In that case, the Court of Criminal Appeals opined the following: pretrial diversion is an extraordinary relief within the exclusive discretion of the prosecuting attorney and available only to qualified defendants. I'm going to omit the citations that the court cites in support of all of these statements. The parties agreed in that case that the defendant was qualified for pretrial diversion. However, eligibility for pretrial diversion does not give rise to a presumption of entitlement to pretrial diversion. And then in exercising its discretion, the state has the duty to focus on a defendant's amenability for correction and consider all of the relevant factors, including evidence that is favorable to a defendant. The relevant factors to be considered by the state are as follows: the circumstances of the offense, the defendant's criminal record, the defendant's social history, the physical and mental condition of the defendant when appropriate, and number 5, the likelihood that pretrial diversion will serve the ends of justice in the best interest of both the public and the defendant. The circumstances of the offense and the need for deterrence cannot be given controlling weight unless they are of such overwhelming significance that they necessarily outweigh all of the other factors. So in this particular case, the court has considered the request for pretrial diversion, or it's not pretrial diversion, judicial diversion, and I'll make the following findings. The circumstances of this offense are fairly straightforward. The child that was involved was a child of very young age, and that the proof was that the child testified that he was tied to a chair. And there is evidence both at the time of the offense that the child was injured by photographs that were introduced, and I'm referring specifically in the record now to Collective Exhibit 3. And Collective Exhibit 3 is a series of photographs which show a series of injuries to the child's wrists. And I hold those up, basically for you to see which ones I'm referring to, that there was an injury to the child's wrist where the child had a mark alleged from the rope and from being tied to a chair. And specifically referring to 3E, I think that is, 3E, which shows the most severe injury to the child's wrist, which is a mark shown there that's a cutting into the flesh of the child's wrist. The circumstances of the case are that she was charged with, in the original indictment, she was charged with aggravated child abuse. And it says that the indictment charges her with, therefore, unlawfully, feloniously, and knowingly, other than by accidental means, treated R.C., a child under 8 years of age, in such a manner to inflict injury, and the act of abuse resulted in serious bodily injury to R.C. The jury found her not guilty of that charge, as well as of the second charge of kidnapping. But they did find her guilty of reckless endangerment. A jury question upon, which is posed by the jurors, is nothing more than perhaps one juror's question about a particular aspect of the law. That does not necessarily, in this court's opinion, reflect the entire jury mindset or the thinking that they envisioned or the thinking that they employed in reaching their decision in the case. Reckless endangerment is a Class A misdemeanor, but it's basically, by statute, can be in a situation where a person places someone in an imminent position of peril. For example, the definition of reckless endangerment under the law is that a person commits an offense who recklessly engages in conduct that places or may place another person in imminent danger of death or serious bodily injury. That's the definition. That's the definition that the jury was given. Someone who ties a child who is unruly to a chair using restraints on the hands and arms of that child can be considered, and I think the jury in this case found that it placed that child in a position where he was in imminent danger of serious bodily injury and did sustain serious bodily injury because he has permanent injury to his wrists and arms. And I can see that the jury could have considered that the defendant in this case was recklessly engaging in conduct that placed that child in that. There's no question this child testified that his grandmother had tied him to a chair. And that was both at the time and in his testimony. And the jury obviously credited that, because if they didn't believe that that was the case, they did not believe that the child was truthful in his description of what happened, it is this court's opinion they would have found the defendant not guilty of all charges and acquitted her on all charges. So as far as the nature and circumstances of the offense, this court is of the opinion that the offense was one that did particularly present a danger to the child of significant serious bodily injury. The court doesn't have any question about the amenability to rehabilitation of the defendant based on the fact of whether or not she is or is not amenable to rehabilitation. I think she's been out of jail now for some time and there's no new offenses that have occurred. So there's no reason to believe that she's not able to have that. The circumstances of the offense, which are the factors that the state would have considered, I've dealt with that situation. Her criminal record, it's unclear that she has, apparently there's no record that she has any prior convictions that would disqualify her from being eligible for judicial diversion. There is some evidence that perhaps there was some prior criminal cases that were brought, but there's no convictions as of record right now. The social history is that, again, I don't have anything before me to show what the actual social history was, other than this was her grandchild and that there was a history of her taking care of the children on a regular basis for her son, who is, I think, in school or in a class or something in another county. Physical and mental condition of the defendant when appropriate. There's no indication that the defendant has any physical or mental conditions that I'm aware of or that came forward at trial. The likelihood that pretrial diversion will serve the ends of justice in the best interest of both the public and the defendant. This court deals with a number of cases on a regular basis, and in the arraignments that we go forward here, unfortunately there is a recurring theme of cases involving child abuse. Children are being neglected, children are being injured, they're being abused on a regular basis by people throughout Dixon County and the 23rd Judicial District. The numbers of those cases seems to be on the rise. Many of them are drug-related cases, and some of those are neglect. In this case, the court is of the opinion that the granting of judicial diversion would not serve the ends of justice or the best interest of both the public and the defendant. I think that the circumstances of the offense do not have the controlling weight in this, but I do think that the deterrent effect would be something that this court must consider. I think that the seriousness of the offense and the seriousness of the injury, and frankly, the lack of contrition by the defendant, as evidenced at trial as well as at the sentencing hearing, that there is nothing that would indicate to me that she is warranted in having judicial diversion. So I'm of the opinion that judicial diversion is not appropriate, and therefore I decline to grant the request for judicial diversion. Then we move to the sentencing. Clearly, the sentence carries a possible sentence of 11 months and 29 days in the county jail. The court is required to always consider the factors that are set forth in the sentencing procedures and considerations that I have to look at when I'm imposing a sentence, and those are found in Tennessee Code Annotated 4035-103. The sentencing considerations that I am required to consider are the following. To implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based on the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to those likely to commit other similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. The sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. The potential or lack of potential for the rehabilitation or treatment of the defendant should be considered in determining the sentence. Alternatives are a length of time of a term to be imposed. The length of the term of probation may reflect the length of treatment or rehabilitation program in which the participant is a condition of the sentence. Trial judges are encouraged to use alternatives to incarceration to include requirements of reparation, victim compensation, community service, or all of these. So those are the things that this court is required to look to consider whether or not there should be confinement or not confinement. In addition to that, I'm required to consider, although this is not one where I would be considering the range or even a sentence within the range, but it has to do, I suppose, with, you could say we're dealing with the range of a misdemeanor. So I will, considering the mitigating factors that Mr. Bell-Myers has raised, those mitigating factors are found in 4035 113. The first is the defendant's criminal conduct neither caused nor threatened serious bodily injury. That does not apply. In my opinion, it did cause and result in serious bodily injury. This child has permanent nerve damage, as both stated by him in his victim impact statement, as well as by his mother's impact statement, and by the medical proof that was produced at trial. The defendant acted under strong provocation does not apply. Substantial grounds exist tending to excuse or justify the defendant's criminal conduct, although failing to establish a defense. Number one, the defendant denied any culpability, denied tying the child to the chair whatsoever, denied that she did anything wrong. And under those circumstances, there are no substantial grounds which exist tending to excuse or justify her criminal conduct. The court finds, as in this, the jury found, that the defendant engaged in conduct which recklessly engaged in conduct which posed a threat and of serious bodily injury and did cause serious bodily injury. Looking through the other mitigating factors there, and I'm not going to go through each one, but I do not find that any of the mitigating factors apply in this court. Then going to the enhancement factors, the defendant doesn't have a previous history of criminal convictions that would apply. The only thing I would say is number 4, the victim of the offense was particularly vulnerable because of age or physical or mental disability. But again, that is a factor that I find would apply. You could argue that it wouldn't apply because of child abuse. It has to necessarily involve a child, but she was not found guilty of child abuse. She was found guilty of reckless endangerment. So I find that that would apply in that particular situation. Personal injuries inflicted upon, the amount of damage to property sustained by them were particularly great. This child has permanent nerve damage as a result of the ligatures that were placed on his wrists when he was tied to a chair, that this court finds to be the cause of those injuries based on the medical proof as well as the child's testimony, and therefore I find that to be a factor as well. Based upon all of these factors, I'm of the opinion that a sentence of 11 months and 29 days in the county jail should be imposed, and that sentence will be served, but will be suspended after she has served a total of 60 days in jail with credit for time served. That was to be the judgment of the court.